I'm Carol Lawson, an estate planning and probate attorney in Clearwater, Florida. This is a pre-recorded webinar. Welcome to Why You Need an Estate Plan, tonight's webinar. There is so much uncertainty right now in our world, and what we're offering you tonight is some information and concrete suggestions that can give you some reassurance as you plan for your retirement. We've assisted our clients with planning strategies, asset preservation, investing for income estate planning, and Social Security maximization. Estate planning can avoid unnecessary legal costs, avoid unnecessary taxes, both federal and state, along with ensuring that assets go to where you want them to go. You can protect your spouse and children from unforeseen events after you die. You can protect your children from your spouse's remarriage and from unforeseen divorces and lawsuits after they inherit your money. You can do all these wonderful things when it goes right, but when estate planning goes wrong, it's really bad. Here's an actual case from the 1990s showing why you need to keep your estate planning up to date. A teacher in New York in her early 20s. She got her first job, and at the time she wasn't married. She had a mother, an aunt, and a sister, and she made them the beneficiaries on her pension plan called A403B. Subsequently, she got married, and they had a will, and the will said, hey, if I die, my husband gets everything. Her husband had a will said, if I died, my wife gets everything. They also had 3 children, and they said, okay, if we both die, we want our children to get a third, a third, a third. She retired from her teacher job and moved to Florida with her husband. When she was in her 60s, she dies. At the time of her death, her mother and aunt had predeceased her. Her sister was alive, and she received the $1 million in the New York Teachers 403B retirement plan. The husband did not get the money. Now, the article goes on to say that he tried to get in touch with her sister, but she would not take his calls. The husband goes to court, goes on to say he went to court, and the will say if she dies, I get everything. The judge, however, said, I'm sorry, sir, I can't help you. This is not your money. Your wife left this money to her sister. This money belongs to her sister, not you. It's not your money. The article goes on to say he appealed it to a higher court. That judge told him the same thing. This isn't your money. It's the sister's money. He appealed it again. The third judge told him the same thing. Why, you ask, did the sister get the money? The beneficiary document for the pension plan, called a custodial beneficiary document on a retirement plan, life insurance, Roth, IRAs, annuities, IRAs, 401k, the beneficiary trumps the will. Let me repeat, the beneficiary trumps the will. This is why estate planning is critical. You can avoid or reduce tension, infighting, and avoid emotional trauma by regularly updating your estate planning documents. Also, when you draft a trust, you must execute it. An unsigned, unwitnessed, unnotarized trust is not valid. Also, an unfunded trust is of no value. You need to fund your trust. There's a statistic in estate planning that over 70% of people that go out and do buy a trust or do work with an attorney never fund the trust. We don't want you to be a statistic. When we do your trust, we will assign you personal property to fund your trust. We include quitclaiming your Florida real estate to your trust as part of your estate plan. If you bring in your beneficiary forms, we will help you complete them. We don't want you to be a statistic. Let's say we have a second marriage. Each has a kid from their previous marriage and no prenuptial agreement. There are 2 ways this estate planning usually goes. Either my kid gets my stuff and yours gets yours, or the kids split it 50-50. The other option is whichever spouse dies last, their kid gets it all. The husband comes in. His plan was as follows. If he die, he want his wife to be taken care of. If she dies, he want to be taken care of. But if they both die, he had a daughter from his previous marriage. She had a son from a previous marriage, and he wanted the estate split 50-50 between the 2 children. Now, his stuff coming into the marriage was worth $1 million, and her stuff was worth $300,000. This was very generous of him. His daughter, however, is not going to like it. So he procrastinates in coming in and signing his documents for months. I get a phone call, and the wife says that he has had a massive heart attack. He was in the hospital, and without speaking another word, he passed away. Even though his plan was he wanted everything to go half and half to the children, that's not what actually happened when he passed away. The wife was the primary beneficiary on all of their accounts, or a joint owner. She was a joint owner on the bank accounts and the house, things like that. So she inherited the entire $1 million of assets. She did not get along with her stepdaughter, and they began a court battle that lasted years. The wife won. After the court battle, she updated all the beneficiaries on all of her accounts to make her primary beneficiary her son. If the husband would have spent an hour in our office executing his estate plan and maybe an hour transferring assets, his daughter would have been protected. Now, what are components of a good estate plan? A good estate plan calls for a clear, simple disposition of assets. Ultimately, estate planning is the accumulation, the preservation, and the disposition and the distribution of your assets. It should be clearly defined as to who gets what or what money goes to who. You think your daughter's getting the house? Maybe not. You need primary beneficiaries. You need contingent beneficiaries. In the husband's case, he needed the trust to become irrevocable at the death of the first spouse, so his second wife couldn't cut his child out. You need to have your house in a trust. You need to assign or retitle your stock to a trust. You need to have the trust as beneficiaries on your bank accounts, retirement plans, IRAs, mutual funds, and any other property but your car. Another thing to remember is stepchildren are not next of kin. They cannot inherit unless you specifically name them in your will or trust. You just have to make the simple decision to do your estate planning, and I'll do all the heavy lifting. We're going to do all the hard stuff. All you have to do is say, yeah, this is who I want for my executor. This is who I want for my beneficiary. It's simple, it's inexpensive, it's quick. You can do it from your sofa. What's the difference between per capita and per stirpes? What is per capita? Well, it's a different type of beneficiary plan. Most custodians actually have a default as to what happens if you mess up your beneficiaries. For example, we have a mother and father. We have 3 children. They wanted to go a third, a third, a third. And let's give them a couple grand gifts. Child number 1 has a few kids. A child predeceased the parents. If it was per capita, if that child's not there to receive the inheritance, what would happen is when mom and dad pass away, the 2 other surviving siblings get the whole pot. So instead of going a third, a third, a third, it goes 50-50. Guess who just got accidentally disinherited the deceased child's child, their grandchild? Now, under per stripes, if the child predeceases you, instead of going 50-50 to the surviving kids, it would still be thirds with the deceased child share going to their child. This is the most common way we draft beneficiary provisions unless the client specifies otherwise. Here's the fact about estate planning. A little bit of knowledge is a dangerous thing, and you don't know what you don't know. For example, minors' shares will need to be held in trust. You cannot title property or vehicles to minors. You don't have to be an expert, and you probably don't want to be an expert. You want to work with someone who is an expert that can tell you if you need per capita, per stirpes, or some completely different alternative method. That's why you should come to us. Some of you have a will. Some of you have a trust. Some of you have nothing in place. Each of these situations work differently. How does a will distribution plan work? Well, you designate an executor in the will or a personal representative. When you die, your personal representative has to file the will with the probate court and prove the will. Prove a will? Yes. The court doesn't know how many wills there are. What if there's 5 or 10 wills hanging around out there? They have to choose which will they're going to allow you to use to distribute the assets. It may not be the last will if it was not properly executed. Then number 2, then the court is going to appoint the personal representative. Your personal representative named in the will is just a recommendation. A lot of times wills get contested. That's a problem for another time. Now you're in probate court, and did you know that this is open to the public? Anyone can go down the courthouse, pay a small clerk fee, and see your entire case. You got court costs, you got attorney fees. The statute says probate fees are 1 to 3% of the assets, plus additional cost. Plus, if it's a contested case, you can charge additional attorney's fees. What does that even mean? It means we add up all the assets which have to be distributed through the probate court case in a basic formal administration. We then take 3% of the value, or a minimum of $6,000 plus the filing fee, publication fee, and any other court costs. Now, under some circumstances, depending on the assets and how long ago they passed away, you may be able to file a summary administration, which is significantly cheaper. So do you think it makes sense to spend an hour or 2 of your life to get your estate planning done so that your loved ones don't have any court costs or attorney's fees? All you have to do is take action. Don't procrastinate. Do it now. Also, wills don't really allow for any asset protection. What if your daughter inherits the money and she's got a lien or a judgment because she had a car accident or she has credit card bills? Or what if your daughter inherits the money and then she gets divorced 3 years later? Do you want half of that money going to somebody you didn't mean for to go to? What if you give your money to your daughter, then she gets divorced 5 years after you died? He gets half your money, then he gets remarried, then he dies, and half your money ends up with some stranger. That's money that should have gone to your grandkids. There's no control from the grave with a will. How does a trust-centered plan work? Well, first of all, you can designate a trustee or a co-trustee. You can have multiple backups like a hierarchy. You can designate who's in control. If you don't have a loved one maybe, or you don't have any family members, you don't have children that you want to put on there, that's fine. I have solutions for this. We can use corporate trustees. We can help you fix your problems no matter what your situation is. Also, you don't have to prove the trust in court. There's no probate court other than filing a notice of trust. It's a private process. People can't see what you're doing and what you set up for your affairs. It's all private, no court costs. If you want to protect your spouse, if you want to protect your loved ones from unforeseen divorces, unforeseen car accidents, you can plan for it in advance. You need to structure your affairs to protect your loved ones. And the simple way to do that is with a properly structured trust document set up by an expert. Don't go to LegalZoom and click a few boxes and get a trust that will not fix your problems or may not be structured correctly for your state. Also, they will not help you fund it. They will not help you pick the type of trust needed for your specific situation. There's many different types of trusts. You got a revocable living trust. What does revocable mean? Revocable means you can change it anytime you want. You're in control. You're the trustee. You can make changes. You can name your successor trustee. You can avoid probate, unnecessary court costs, and attorney's fees. You're not going to see a trust get contested. I've never seen anyone contest a trust. I've seen many wills get contested. Wills get contested all the time. And what do you want? What if you want to preserve the assets for a surviving spouse or your heir? What if you want control from the grave? What if you want little Johnny to get the money, but you want him to go to college, or you want him to have some income when he retires? You can actually structure that to have what we call control from the grave if that's your goal. Another type of trust is irrevocable. Irrevocable means you cannot change it. Why would someone set up an irrevocable trust? Well, you might have some assets that you want protected from lawsuits or creditors. You might want to protect your money. Have you ever heard someone say, I don't want the nursing home to get all my money? There's 4 ways that you can avoid a catastrophic Medicaid spend down. There's 4 ways that you can make sure the nursing home doesn't get all your money, but we're not going to go into that today. You know, something we do for our clients is we explain all that and we help them make smart choices to protect their money. But that's not what this webinar is about today. Now, one of the 4 ways is estate planning, but one of the challenges you have to stay under certain thresholds. There's a 5-year look-back period for this one method. Please don't listen to the webinar tonight and run out and set up an irrevocable trust. A little bit of knowledge is a dangerous thing. You don't know what you don't know, and you just need a little help. When you come to meet with me and become a client, I'm going to take the time to educate you, sit and help you fill out your transfer forms and beneficiary forms. There are several types of irrevocable trusts. Another is a special needs trust or supplemental needs trust. And there are more than one type of these trusts too. What's a special needs trust? There are lots of people that are receiving government benefits. They're getting a check because they qualify for a government benefit. But you know what? If they came into a bunch of money, inherit money, the government check stops. If there's someone that you want to benefit and transfer wealth when you die, but you don't want their benefits to get cut off, you need a special needs trust. So if you have a child or a loved one, you need to set up a third-party supplemental needs trust for them where your assets will go upon your death. We can help you with this. We do a lot of these, and the purposes of them is to protect the beneficiary and still gets the government check. You're basically appointing a trustee that can help them with things like health, education, maintenance, support. You want to be able to help that special needs person, but you don't want to mess up their benefits. There are many types of revocable and irrevocable trusts, more than we have time to discuss. Another probate avoidance tool is a ladybird deed. What you do is maintain ownership and full control of your property, keeping your homestead exemption, and transfer your property free from probate directly to your beneficiaries upon your death by recording the death certificate. Some other basic documents you need are a durable power of attorney, a medical power of attorney, HIPAA release, and a will. What's a durable power of attorney? It's a document that only matters while you're living. The power of attorney is null and void once someone dies. Do not put your child's name joint on your bank account. Put them on as payable on death or in trust for. Why should you not put your child's name on your bank account or house? Well, is your child married? Yes. Does he drive a car? Yes. Does he file a tax return? Yes. Is it possible his health could decline? Of course, anybody's could. Well, if you put your son on all of your stuff and he gets divorced or has a car accident or the IRS is coming after him or he has medical bills, someone will be coming after his assets and he's on all your stuff. Guess who else has money they can come after? You. Sometimes jointly titling an asset might make sense. A lot of times it's a really bad idea. There's tax implications. For example, having your son on your house blows a tax benefit. He's not living there with you or paying bills. He may even own another home in Florida. Now, when you die, your son would have capital gains taxes. A durable power of attorney is a document used during your life. For example, I have several bank accounts. I have company, corporate accounts. Well, my business account is not joint with anyone. It's a company account. One day I was busy, so my son ran up to the bank. They told him he can't do the deposit because he's not on the account. He called me. I said, "You have a power of attorney." Read that last paragraph. Basically, it said he could act as if I was physically present. Now, there's different kinds of power of attorney. He has my immediate power of attorney. He's authorized to help me right now, but my brother, who's a CPA, he's my backup. He does not. What if my son is incapacitated? What if he predeceases me? My brother's the backup. Do you think my brother can walk into the bank, close my bank accounts, and take off to Mexico? No, he's got what's called a springing provision. It only takes effect when certain criteria have been met. What's a medical power of attorney? It's a legal instrument that designates a person to make medical decisions when you can't do it for yourself. For example, if you're in a coma, you've had a car accident, you're at the hospital, and the family's gathering around, and the doctor says, "I can't help you." Have you ever heard of HIPAA? You're heard of the HIPAA, and doctors are paranoid about getting sued, so they will often shut down. They won't share information. You need a medical power of attorney, known as a designation of healthcare surrogate, for a couple reasons. One is you need it to allow for the medical professionals to talk to your loved ones without having to go to court. For example, if my 19-year-old is in a car accident and they transfer him to another hospital and I go to the old hospital and say, "Where's my son?" They literally don't even have to tell me where they transferred him to because of his private medical information unless I provide a healthcare surrogate and HIPAA release. So what is a living will? It's a document that addresses whether you want them to pull the plug and other what conditions. Do you all remember Terry Schiavo? She was on life support for about a decade. Her husband said her wishes were to be taken off of life support. Her parents said, "No, we want her to be kept on the feeding tube." She was brain dead in a coma, so they all ended up in court. Do you know if Terry just would have had a living will that never would have happened? All this stuff takes an hour or two to fix. It just takes an hour or two to fix. It's simple, it's easy, it's inexpensive, but Terry obviously never got around to it. And sadly, her family ended up in a horrible court battle. It took years and ended up at national news. Don't do that to them. Take action. Fix these problems. You want these documents to speak for your wishes when you can't talk. In conclusion, we will talk to you about your estate planning goals over the phone for 15 minutes at no charge. If you wish to come into our office, there is a consultation charge for the appointment. I'm going to tell you exactly how to fix your estate planning issues based upon your individual circumstances and assets. What should I bring to the appointment? Your existing will or trust, any power of attorneys, usually a recent tax return, some copies of your investments, your 401k, or your brokerage accounts and life insurance policies. To recap, what is estate planning? Ultimately, it's the accumulation, preservation, and distribution of your estate. We need to make sure you're good in all those areas: accumulation, preservation, and distribution. So give me a call.